afternoon, everybody. Thank you for joining us for another edition of Condo Insider. With me today, I have, Lance is going to be one of our new hosts. So today we're going to do a show together. Lance Fujisaki, he is an attorney with Anderson Fujisaki. I always can kind of remember Lane, but Philip Lane had retired a few years ago. It's kind of hard to remember the names again. But in a minute, Lance will be joining us. Hi, Lance.
Hi, Raelene.
Nice to see you, and I'm so glad that you're able to join me today. And you also agreed to be one of our hosts going forward.
Thank you for inviting me.
So I know you've been a condo attorney for a long time it's Anderson Fujisaki, right?
Yes.
Okay. So today we're going to be talking about proxies because it's annual meeting season. So oftentimes I get a lot of questions from even with my homeowners about the proxies. I always have to remind them what each of the boxes mean. So we're going to do a little bit of a review. Lance is going to take us through what a proxy is, why do we use it, and the meaning of each of the check boxes. So without further, Lance, we can start. So on our first screen on slide number 2 on our PowerPoint, we have a sample of what a standard proxy form might look like for your condos. So Lance, why don't you tell us what it means for a proxy? Why do we have to have it?
Okay, thank you for inviting me to talk about proxies today. I'd like to provide just a few caveats before I begin to answer your questions. First, obviously, today I'm providing general information and not giving legal advice. The answers to specific questions will depend upon the facts and circumstances. My comments will be focused on condominium associations, which are governed by Chapter 514B of the Hawaii Revised Statutes. I'll just refer to this as Chapter 514B or Section 514B, the Condominium Property Act. And you may find a copy of Chapter 514B on the state legislature's website. I want to distinguish this from planned community associations, which are different from condominium associations. And planned community associations are governed by Chapter 421J. And so just keep that in mind if you are part of a planned community association. Much of what I say will not apply to your association. So just be careful about that. So the word proxy can mean at least 2 things. And this is maybe part of why proxies are so mysterious and kind of difficult to get your mind around. So proxy can refer to the written instrument or document that authorizes one person to vote at a meeting in place of the member who signed the document. So it can refer to the document or piece of paper, but it could also refer to the person who's assigned the right to attend and vote at a meeting. Chapter 514B also uses the phrase proxy vote to refer to the vote of a proxy holder. So the word proxy has other meanings, but when we speak of proxies in the context of a meeting, that's what we usually are referring to. Because of these multiple meanings, speaking about proxies can be confusing. It's as if the word automobile were used to refer to both motor vehicles and the driver of the vehicle. So for purpose of clarity, I'm going to use the word proxy to refer to the written document signed by the owner, and the word proxy holder to refer to the person who's appointed to represent the owner at a meeting. So subject to those comments, in the context of a condo association, when an owner submits a proxy to the association, the owner is appointing the proxy holder to serve as the owner's agent at a meeting to vote on the owner's behalf. I'd also like to add this. Proxies are really fascinating documents for several reasons. They're critically important documents for our condo associations. They can mean the difference between having a quorum and not having a quorum and having to adjourn the meeting or reschedule. And they're like little gems on their face. They look like a simple form. They're short, simple. They have a few check boxes, space to fill in the name of a proxy holder, and the date and signature lines. Most times they don't contain anything controversial. But like a gem, they are very valuable because packed inside each proxy is the vote of an owner. And every owner's vote is very important. The proxies can and do determine the outcome of most board elections. In some situations, individual owners may collect large numbers of proxies and elect candidates that they favor. And in other cases, owners may use proxies to give their vote to the boards, and the board would vote proxies. The steps that must be taken to ensure that proxies are valid and also make proxies fascinating. These steps require a lot of care. Associations must strictly comply with the requirements of Chapter 514B and the bylaws. A few minor errors here or there can render proxies invalid. So hopefully the discussion today will help to prevent those kinds of problems from happening. There are highly technical procedures that an association must follow before proxies can be mailed to owners. And I'm not going to touch on all of those procedures, but I'd like to refer you to the January 28, 2023 Condo Insider Program featuring my friend Chris Goodwin, which is available on the website, ThinkTech Hawaii. And please watch that program for a discussion about the procedural requirements, which I will not cover today.
So once usually you get your annual meeting packet will include the proxies and they have check boxes. So what do each of those check boxes mean?
Okay, well, before I answer that, let me just discuss what proxies are used for.
Okay.
So most associations, condo association bylaws, they set a quorum for association meetings. And usually this is set at more than 50% of the common interest, although it can be lower. But what this means is that for most associations to transact any business at a meeting, there has to be present in person or by proxy owners of units to which are pertinent more than 50% of the common interest. Unfortunately, if your association is running smoothly, owners are happy and satisfied, it can be really hard to get over 50% of the common interest present in person at a meeting. People are busy with work, family, other things, and spending a few hours at an association meeting is just not what they want to do. So without proxies, most associations wouldn't be able to achieve a quorum, and they wouldn't be able to conduct business at their meetings. So for those owners who don't want to or can't attend a meeting, proxies give those owners a means to have their votes counted at the meeting. The condo law in Hawaii has authorized proxy voting for decades now, and the proxy provisions have been fine-tuned over many years. I think historically, of all the provisions in Chapter 514B, probably the proxy provisions have been the provisions that have been amended most frequently. The other thing is that although proxies are really useful for associations, there's nothing that in Chapter 514B that requires associations to send proxies to owners. So, for example, some associations, they always get a good turnout at their meetings. A lot of owners attend, In those kinds of cases, the board may decide that it's not necessary to send proxies because owners attend the meeting, and that's perfectly fine. But for most associations, the boards are going to have to send proxies to achieve a quorum. So, and I think one of the things to keep in mind is that proxies are really technical documents. Before we get to those checkboxes, I wanted to say that they're basically two kinds of proxies. I think we're all used to seeing the standard form proxy that contains those checkboxes that you were alluding to. But there's also these proxies that are provided by apartment owners, and owners have the right to submit proxies that they create on their own, and those kinds of proxies can be very short. They just need to contain basic information. There are 6 pieces of information, and I'll call these owner proxies that the owners create for themselves. On those kinds of proxies, all you need to put on them are 1, the name of the association, 2, the date of the meeting of the association that the proxy is for, 3, the printed names and signatures of the persons giving the proxy, 4, the unit numbers for which the proxy is given, 5, the names of persons to whom the proxy is given, basically the proxy holder, and 6, the date that the proxy is given. So as long as a piece of paper is given to the association with this information, that is a valid proxy by an apartment owner. But on that slide 2, I think it is, which is the standard proxy form that associations can send. This form is a form that's regulated by Chapter 514B. And so this is the type of form that the association would mail to owners. Now, this is not a form that I created. This is one that you provided, Raelene. And so it's a little different from what we would use in terms of the text that's contained on the proxy form. But it's basically similar to what we use. And so on this form, there are 4 checkboxes. And let me just go through these boxes. The first box is to the board as a whole, and that the vote is to be made. We'll be talking about this in a little more detail, but okay, now on this slide, you can see to the board as a whole, and that the vote is to be made on the basis of the preference of the majority of the directors present at the meeting. That's the first box. The second one is to those directors present at the meeting, with the vote to be shared with each director receiving an equal percentage. Third box is to the individual whose name is printed on a line next to this box. And the fourth box is for quorum purposes only. The proxy can also state that if the proxy is returned with no box or more than one of the 4 boxes checked, the proxy shall be counted for quorum purposes only. This would apply even if these words are not included on the proxy. The proxy form on slide 2 contains some additional information that the proxy will be counted for quorum purposes if 1, the proxy is assigned to the owner, that is, the proxy holder and the proxy giver are the same person, which would make no sense, or 2, if the proxy holder does not attend the meeting. I didn't prepare these slides, or this slide in particular, and would caution that since 514B123E does not refer to the latter 2 situations, you should consult with your attorney on whether it's appropriate to include that on the standard form proxy. But getting back to those boxes, on that first box, as you can see on this slide, the first box is to the board as a whole, and that the vote is to be made on the basis of the preference of the majority of the directors present at the meeting. This means that the directors who are present at the meeting can cast votes for the owners who check the first box. The directors will have to gather at the meeting and they'll decide how to cast their votes. And these are just informal meetings. The directors who are not present at the meeting, however, they will not be able to determine how the votes are cast because it requires those directors to be present at the meeting. The second box on the proxy is to those directors present at the meeting with the votes to be shared with each director receiving an equal percentage. This means that each vote will be split so that each director receives an equal percentage. And on the slide 4, there's a calculation on the notes. It says if the common interest of a unit is, and there's a number of 1.58730,159, which is sort of a typical number. And the owner checks box 2, and there's 7 directors present. That interest will be divided by 7. And so each director gets 0.2267573% of the common interest to vote. And so it's all split that way, and each director would cast a ballot reflecting that common interest. So slide 5 shows the third box on the proxy that is to the individual whose name is printed on a line next to this box. So usually if an owner checks the third box, the owner will insert the name of another owner, the blank line. But the owner can insert the name of anyone in this box. The proxy holder does not have to be an owner. There's a note that the proxy holder must be over the age of 18. But I just want to note that there's nothing in Chapter 514B that makes this statement. So if a proxy holder is a minor, you should consult with the association's attorney for advice on what to do with that proxy. The fourth item on the proxy is quorum only. And I wanted to alert viewers to this box because it is a popular box to check, but it does have some adverse effects. So what does a quorum only proxy mean? Quorum only means that the owner wants to be counted in the quorum, but doesn't want to have the owner's vote counted in any business at the meeting. So this is good and bad, okay? It means that the proxy will help to achieve a quorum, which is good. But the bad is that the proxy will not be counted as a proxy on any matter, or the vote will not be counted. In other words, if any motions are made at the meeting, the quorum only proxy will have the effect of a no vote on matters that require a certain percentage of the common interest to adopt. So for motions that only require a majority of those present and voting, quorum only proxies may not have a negative effect. So that's the majority of those present and voting. Then the quorum only proxy is not a problem, other than that it will not allow the owner's vote to be cast. But it can be a problem in this situation. If the association has a quorum requirement of a majority of the common interest, and 51% of the common interest is present in person or by proxy, then of course the meeting can proceed. But if 10% of the common interest is represented by proxies that are quorum only, the association would not be able to adopt any measures that require a majority of the common interest. So the quorum only proxies will be essentially treated as no votes. And the quorum only proxies may also have an adverse effect on elections. If board candidates must be elected by a majority of the members, which is somewhat common, that means more than 50% of the common interest is required to elect each director. And it may be impossible to elect any director if you have a large number of quorum only votes. So because of these concerns, board should discourage owners from checking the quorum box.
So for some owners, especially new owners, because they're not sure what I mean, it's kind of like a foreign document in front of them, especially if they're a first time homeowner. So what happens if they can't attend them, but they want their vote to count? You know, so what happens if they can't, or maybe they're not sure if they can attend, but they really want to make sure that they get their paperwork in. So what happens?
Yeah, I think it's always a good idea to turn in the proxy even if you're sure you can attend, or if you're not sure whether you can attend, or if you definitely cannot attend. In any case, turn your proxy in, give it to somebody who you trust with your vote, and then you just never know what's going to happen. Notices of meetings are sent well in advance of the meeting, and you may just not feel like going to the meeting on that day or evening or morning of the meeting. If you turn in your proxy, you'll be sure, and if you give it to a proxy holder who attends, then you'll be sure that your vote will be cast. But I think some people think, there might be some adverse effect if I eventually on the day of the meeting decide to attend, then I'm somehow going to be adversely affected by that. I won't be able to go to the meeting or cast a vote. But I wanted to assure you that owners almost always have the option to show up for the meeting and vote at the meeting, even if they submitted a proxy. And if they do so, if they show up at the meeting, they can revoke their proxy and cast votes at the meeting, just as if they had never submitted a proxy.
So I always tell some people, I go, if you're not sure, give your proxy to somebody, because when you attend in person, it voids it. But just in case something happens and you really can't attend, at least your voice is going to be heard and your vote is going to count. So that's going to be, to me, that's like your backup, your plan B, in case you're like sitting on the fence, like I might not, I got work, especially when people got work issues and, even though the best plans, they plan to attend, but something always might happen, or traffic,
And it's really not in any owner's interest to have a meeting rescheduled, because it can cost thousands of dollars, to adjourn the meeting to a future date and time. If you have a parliamentarian, attorneys, or have to do additional mail outs, all of those things are very expensive.
Yeah. So I've been a condo owner for a long time, and usually before the annual meeting, there is another notice that's posted months before, and it's about solicitation of proxies and using association funds. So tell us a little bit about that.
Yeah, that's a good question. Why do those notices get posted? And sometimes they may not even be read by owners, especially owners who don't even reside at the project.
Yeah.
So first of all, I wanted to mention that again, Chris Goodwin did a presentation on the procedures for posting and all of that, and procedures before and after proxies are sent. And so I wanted to encourage you to view that. My comments today are going to focus on the proxies themselves and less on these procedures before and after the proxies are sent. But let me just respond to that. That under 514B 123J, or rather I, if the board intends to mail standard form proxies to members at association expense, the board has to first post notice of its intent to distribute proxies in prominent locations within the project at least 21 days before its distribution of proxies. So these posted notices, if you see them, they must have this information. They must say that the board intends to distribute proxies to owners, that if owners want to serve on the board or want to receive proxies, they must submit to the association their request along with a statement, which shall be limited to black and white on white, black text on white paper, not to exceed one single-sided 8.5 by 11-inch page, indicating the owner's qualifications to serve on the board or reasons for wanting to receive proxies. The statement has to be submitted 7 days after the notice is posted, or the board extends this time, whatever that time is. The notice has to say the statement can be submitted by mail, fax, email, or mail or hand delivery to the board, which is usually through the managing agent. And the notice should have the date of posting on it to indicate when it was posted. So keep in mind, if the board fails to post notice, this seemingly kind of a pro forma notice on the bulletin board and in 2 locations at least, if the board doesn't do that, it cannot use association funds to mail proxy forms to owners. So that is a critically important thing that associations must do. For a lot of associations, especially ones with a lot of owners who reside on the mainland or out of state, out of the country, they also mail the notice of distribution of proxies to the owners with basically the same information as in the posted notice. But the association has to physically post notices in prominent locations on the project, meaning at least 2 locations. And that applies, this question comes up sometimes, even if all of your owners don't reside at the project, which is the case at many projects, and they'll never see these notices that are on the bulletin board, you still have to do that. That's just obligatory.
So it has to be posted, and that proxy solicitation notice has to also be mailed to each individual owner?
No, the notice has to be posted, but for a lot of projects, they'll also mail it.
Oh, okay. So sometimes it has a deadline on the date that you have to submit your intent to use association funds to solicit. Are those solicitations included in the board packet? I mean, in the annual meeting packet, or are they mailed separately?
Yes, well, they are included in the packet usually. The statements, let me just talk about those statements. So, the notice that I just mentioned, they talk about submission of statements. And the statements, these are statements by people who want to run for the board and or want to get proxies from other owners. So those statements must be limited to 2 things. First, the owner's qualifications to serve on the board and or the reasons for wanting to receive proxies. And owners shouldn't use those statements to communicate, I hate to use this word, defamatory information to promote personal businesses or other inappropriate reasons. And so about these statements, they need to be received by the board or managing agent before the notice of meeting is sent to owners within 7 days of posting, unless the association provides a longer period. And it's important that the association calculate the various deadlines so that everything is perfectly choreographed. There's a number of deadlines and steps that need to be done, and these all need to be properly aligned. But once the association gets those statements, they need to be reviewed by the managing agent and, if necessary, the association's attorney. And although the question comes up sometimes, what can owners write in these statements? They do have a lot of flexibility on what they can include. But again, if the statements cross the line, the managing agent will, in most cases, contact the owner to ask them to remove inappropriate information, or if they exceed the page limit, to shorten the statement or cut off the statement over 1 page, or do things like that. So those requirements do need to be complied with.
Okay, and then you mentioned that it's reviewed by the managing agent and the association attorney?
Well, that's really discretionary.
Okay,
If there are questions, and all associations, do things a bit differently. But if there are questions about whether whether the statements contain information that may expose the association to claims or are otherwise inappropriate, then that the association may want to refer the question to the attorney.
okay. So what if a request for solicitation arrives after the deadline and after they've already mailed out ones that they have already received?
Now that is the firm deadline, and so the association does not have an obligation to do that.
Okay. So how, who and when and how does the proxy solicitation get processed? So we went over that. So it's reviewed by the managing agent. And then sometimes if it's questionable, it'll get sent to the association attorney. And then your proxies are collected. All the individual proxies are collected by the managing agent, and they have to be turned in by a certain time, date and time.
Right, and so let me just review that again. So you need to send the proxy. It needs to be delivered to the secretary of the association or the managing agent, if there is a managing agent. And then they can be submitted by fax, email, mail, or hand delivery. And if the original proxy is not submitted, the statute says owners must submit a reproduction of the entire original proxy. So the association needs to receive the original entire proxy. What is the deadline for getting all that done? It needs to be no later than 4:30 p.m. Hawaii Aleutian Standard Time on the second business day prior to the date of the meeting to which it pertains. And this means if the meeting is on Saturday, the deadline is 4:30 p.m. on Thursday. If the meeting, okay, Raelene, I'm talking about the proxy forms themselves.
Right.
They need to be submitted at 4:30 p.m. 2 days before the date of the meeting. And this means if the meeting is on a Saturday, the deadline is going to be 4:30 p.m. on Thursday. If the meeting is on Monday, the deadline is going to be at 4:30 p.m. on Thursday. Okay, so these are the proxy forms that are sent with the packet for the annual meeting or the association meeting, whatever kind of meeting.
Okay, and then because we're running out of time, so one last comment. So it has to be turned in either to the secretary of the association or the managing agent. But what about solicitation by the managing agent or employees of the association? Can an employee collect those proxies and then turn them into the managing agent? And
yes, right. So employees, there's not a problem with employees collecting them, and then they can be submitted to the managing agent, of course, by the deadline, 4:30 p.m. 2 days before the meeting. But there's not a problem with that. But the employees of the association should not be soliciting proxies. In other words, asking owners to put their names on the proxies, because
Right.
those are not going to be, they won't be valid for purposes of casting votes.
okay. And then what if somebody wants to change their proxy? They already turned it in and they want to change it. Would they submit a brand new form?
Yes. So as long as it is before the deadline,
Right.
they can change their proxy, and the managing agent should keep a record of the postmark dates of the proxy so that it's clear which one was sent later. And assuming they're mailed or if they're emailed or faxed, there should be a record of that. So the latest document would control over the documents that are sent in previously.
So our time is up. So I really want to thank you, Lance. It's proxies and proxy statements is a long conversation, but we did it in 20 minutes, a little bit over 20 minutes. But I want to thank you so much for being on the show today and also being one of our future hosts. So everybody look forward to seeing Lance on some other future editions of Condo Insider. So thank you, and everybody have a good weekend. Thank you, Lance.
Thank you, Raelene.
Thank you so much for watching ThinkTech Hawaii. If you like what we do, please like us and click the subscribe button on YouTube and the follow button on Vimeo. You can also follow us on Facebook, Instagram, and LinkedIn, and donate to us at thinktechhawaii.com. Mahalo.